Article 7, Executive Department. Section 1. The executive power shall be vested in the President of the Philippines. Section 2. No person may be elected president unless he is the natural-born citizen of the Philippines, a registered voter, able to read and write, at least 40 years of age on the day of the election, and a resident of the Philippines for at least 10 years immediately preceding such election. Section 3. There shall be a vice president who shall have the same qualifications and term of office and be elected with and in the same manner as the president. He may also be removed from office in the same manner as the president. The vice president may be appointed as a member of the cabinet. Such appointment requires no confirmation. Section 4. The president and the vice president shall be elected by direct vote of the people for a term of 6 years, which shall begin at noon on the 30th day of June, next following the day of the election, and shall end at noon of the same date 6 years thereafter. The president shall not be eligible for any re-election. No person who has succeeded as president and has served as such for more than 4 years shall be qualified for election to the same office at any time. No vice president shall serve for more than 2 successive terms. Voluntary renunciation of the office for any length of time shall not be considered as an interruption in the continuity of the service for the full term for which he was elected. Unless otherwise provided by law, the regular election for president and vice president shall be held on the second Monday of May. The returns of every election for president and vice president, duly certified by the Board of Canvassers of each province or city, shall be transmitted to the Congress, directed to the President of the Senate. Upon receipt of the certificates of canvass, the President of the Senate shall, not later than 30 days after the day of the election, open all the certificates in the presence of the Senate and the House of Representatives in joint public session, and the Congress, upon determination of the authenticity and due execution thereof in the manner provided by law, canvass the votes. The person having the highest number of votes shall be proclaimed elected, but in case 2 or more shall have an equal and highest number of votes, one of them shall forthwith be chosen by the vote of a majority of all the members of both houses of the Congress, voting separately. The Congress shall promulgate its rules for the canvassing of the certificates. The Supreme Court, sitting en banc, shall be the sole judge of all contests relating to the election, returns, and qualifications of the president or vice president, and may promulgate its rules for the purpose. Section 5. Before they enter on the execution of their office, the president, the vice president, or the acting president shall take the following oath or affirmation. I do solemnly swear or affirm that I will faithfully and conscientiously fulfill my duties as president or vice president or acting president of the Philippines, preserve and defend its constitution, execute its laws, do justice to every man, and consecrate myself to the service of the nation. So help me God. In case of affirmation, last sentence will be omitted. Section 6. The President shall have an official residence. The salaries of the President and Vice President shall be determined by law and shall not be decreased during their tenure. No increase in said compensation shall take effect until after the expiration of the term of the incumbent, during which such increase was approved. They shall not receive during their tenure any other emolument from the government or any other source. Section 7. The President-elect and the Vice President-elect shall assume office at the beginning of their terms. If the President-elect fails to qualify, the Vice President-elect shall act as President until the President-elect shall have qualified. If a president shall not have been chosen, the vice president-elect shall act as president until a president shall have been chosen and qualified. If at the beginning of the term of the president-elect shall have died or shall have become permanently disabled, the vice president-elect shall become president. Where no president and vice president shall have been chosen or shall have qualified, or where both shall have died or become permanently disabled, the president of the Senate, or in case of his inability, the Speaker of the House of Representatives, shall act as president until a president or vice president shall have been chosen and qualified. The Congress shall by law provide for the manner in which one who is to act as president shall be selected until a president or a vice president shall have qualified. In case of death, permanent disability, or inability of the officials mentioned in the next preceding paragraph. Section 8. In case of death, permanent disability, removal from office, or resigning of the president, the vice president shall become the president to serve the unexpired term. In case of death, permanent disability, removal from office, or resignation of both the president and vice president, the president of the Senate, or in case of his inability, the Speaker of the House of Representatives, shall then act as president until the president or vice president shall have been elected and qualified. The Congress shall by law provide who shall serve as president in case of death, permanent disability, or resignation of the acting president. He shall serve until the president or the vice president shall have been elected and qualified, and be subject to the same restrictions of powers and disqualifications as the acting president. Section 9. Whenever there is a vacancy in the office of the vice president during the term for which he was elected, the president shall nominate a vice president from among the members of the Senate and the House of Representatives, who shall assume office upon confirmation by a majority vote of all the members of both houses of the Congress, voting separately. Section 10. The Congress shall at 10 o'clock in the morning of the third day after the vacancy in the offices of the president and vice president occurs, convene in accordance with its rules without need of a call, and within 7 days enact a law calling for a special election to elect a president and a vice president, to be held not earlier than 45 days nor later than 60 days from the time of such call. The bill calling such special election shall be deemed certified under paragraph 2, section 26, article 6 of this Constitution, and shall become law upon its approval on third reading by the Congress. Appropriations for the special election shall be charged against any current appropriations and shall be exempt from the requirements of paragraph 4, section 25, article 6 of this Constitution. The convening of the Congress cannot be superseded, nor the special election postponed. No special election shall be called if the vacancy occurs within 18 months before the date of the next presidential election. Section 11. Whenever the President transmits to the President of the Senate and the Speaker of the House of Representatives his written declaration that he is unable to discharge the powers and duties of his office, and until he transmits to them a written declaration to the contrary, such powers and duties shall be discharged by the Vice President as acting President. Whenever a majority of all the members of the Cabinet transmit to the President of the Senate or to the Speaker of the House of Representatives the written declaration that the President is unable to discharge the powers and duties of his office, the Vice President shall immediately assume the powers and duties of the office as acting President. Thereafter, when the President transmits to the President of the Senate or to the Speaker of the House of Representatives his written declaration that no inability exists, he shall reassume the powers and duties of his office. Meanwhile, should a majority of all the members of the Cabinet transmit within 5 days to the President of the Senate and to the Speaker of the House of Representatives the written declaration that the President is unable to discharge the powers and duties of his office. The Congress shall decide the issue. For that purpose, the Congress shall convene, if it is not in session, within 48 hours, in accordance with its rules and without need of call. If the Congress within 10 days after receipt of the last written declaration, or if not in session, within 12 days after it is required to assemble, determines by a 2/3 vote of both houses, voting separately, that the President is unable to discharge the powers and duties of his office, the Vice President shall act as President. Otherwise, the President shall continue exercising the powers and duties of his office. Section 12. In case of serious illness of the President, the public shall be informed of the state of his health. The members of the Cabinet in charge of national security and foreign relations, and the Chief of Staff of the Armed Forces of the Philippines shall not be denied access to the President during such illness. Section 13. The President, Vice President, the members of the Cabinet, and their deputies or assistants shall not, unless otherwise provided in this Constitution, hold any other office or employment during their tenure. They shall not, during said tenure, directly or indirectly practice any other profession, participate in any business, or be financially interested in any contract with, or in any franchise, or special privilege granted by the government, or any subdivision, agency, or instrumentality thereof, including government-owned or controlled corporations, or their subsidiaries. They shall strictly avoid conflict of interest in the conduct of their office. The spouse and relatives by consanguinity or affinity within the 4th civil degree of the President shall not during his tenure be appointed as members of the constitutional commissions, or the office of the Ombudsman, or as secretaries, undersecretaries, chairmen, or heads of bureaus or offices, including government-owned or controlled corporations, and their subsidiaries. Section 14. Appointments extended by an acting President shall remain effective unless revoked by the elected President within 90 days from his assumption or reassumption of office. Section 15. 2 months immediately before the next presidential elections and up to the end of his term, a President or acting President shall not make appointments, except temporary appointments to executive positions when continued vacancies therein will prejudice public service or engender public safety. Section 16. The President shall nominate, and with the consent of the Commission on Appointments, appoint the heads of the executive departments, ambassadors, and other public ministers and consuls, or officers of the armed forces from the rank of colonel or naval captain, and other officers whose appointments are vested in him in this Constitution. He shall also appoint all other officers of the government whose appointments are not otherwise provided for by law, and those whom he may be authorized by law to appoint. The Congress may, by law, vest the appointment of other officers lower in rank in the President alone, in the courts, or in the heads of departments, agencies, commissions, or boards. The President shall have the power to make appointments during the recess of the Congress, whether voluntary or compulsory, but such appointments shall be effective only until disapproval by the Commission on Appointments or until the next adjournment of the Congress. Section 17. The President shall have control of all the executive departments, bureaus, and offices. He shall ensure that the laws be faithfully executed. Section 18. The President shall be the Commander-in-Chief of all armed forces of the Philippines, and whenever it becomes necessary, he may call out such armed forces to prevent or suppress lawless violence, invasion, or rebellion. In case of invasion or rebellion, when the public safety requires it, he may, for a period not exceeding 60 days, suspend the privilege of the writ of habeas corpus or place the Philippines or any part thereof under martial law. Within 48 hours from the proclamation of martial law, or the suspension of the privilege of the writ of habeas corpus, the President shall submit a report in person or in writing to the Congress. The Congress, voting jointly, by a vote of at least majority of all its members in regular or special session, may revoke such proclamation or suspension, which revocation shall not be set aside by the President. Upon the initiative of the President, the Congress may, in the same manner, extend such proclamation or suspension for a period to be determined by the Congress, if the invasion or rebellion shall persist and public safety requires it. The Congress, if not in session, shall, within 24 hours following such proclamation or suspension, convene in accordance with its rules without need of a call. The Supreme Court may review, in an appropriate proceeding filed by any citizen, the sufficiency of the factual basis of the proclamation of martial law, or the suspension of the privilege of the writ, or the extension thereof, and must its decision thereon within 30 days from its filing. A state of martial law does not suspend the operation of the Constitution, nor supplant the functioning of the civil courts or legislative assemblies, nor authorize the conferment of jurisdiction on military courts and agencies over where civil courts are able to function, nor automatically suspend the privilege of the writ. The suspension of the privilege of the writ shall apply only to persons judicially charged for rebellion or offenses inherent in or directly connected with invasion. During the suspension of the privilege of the writ, any person thus arrested or detained shall be judicially charged within 3 days, otherwise he shall be released. Section 19. Except in cases of impeachment or as otherwise provided in this Constitution, the President may grant reprieves, commutations and pardons and remit fines and forfeitures after conviction by final judgment. He shall also have the power to grant amnesty with the concurrence of a majority of all the members of the Congress. Section 20. The President may contract or guarantee foreign loans on behalf of the Republic of the Philippines with the prior concurrence of the Monetary Board and subject to such limitations as may be provided by law. The Monetary Board shall within 30 days from the end of every quarter of the calendar year submit to the Congress a complete report of its decision on applications for loans to be contracted or guaranteed by the government or government-owned and controlled corporations, which would have the effect of increasing the foreign debt and containing other matters as may be provided by law. Section 21. No treaty or international agreement shall be valid and effective unless concurred in by at least 2/3 of all the members of the Senate. Section 22. The President shall submit to the Congress within 30 days from the opening of every regular session, as the basis of the General Appropriations Bill, a budget of expenditures and source of financing, including receipts from existing and proposed revenue measures. Section 23. The President shall address the Congress at the opening of its regular session. He may also appear before it at any other time. Article 8. Judicial Department. Section 1. The judicial power shall be vested in one Supreme Court and in such lower courts as may be established by law. Judicial power includes the duty of the courts of justice to settle actual controversies involving rights which are legally demandable and enforceable, and to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government. Section 2. The Congress shall have the power to define, prescribe, and apportion the jurisdiction of the various courts but may not deprive the Supreme Court of its jurisdiction over cases enumerated in Section 5 hereof. No law shall be passed reorganizing the judiciary when it undermines the security of tenure of its members. Section 3. The judiciary shall enjoy fiscal autonomy. Appropriations for the judiciary may not be reduced by the legislature below the amount appropriated for the previous year, and after approval shall be automatically and regularly released. Section 4, Number 1. The Supreme Court shall be composed of a Chief Justice and 14 Associate Justices. It may sit en banc, or in its discretion, in division of 3, 5, or 7 members, and a vacancy shall be filled within 90 days from the occurrence thereof. Number 2. All cases involving the constitutionality of a treaty, international or executive agreement, or law, which shall be heard by the Supreme Court en banc, and all other cases which under the rules of court are required to be heard en banc, including those involving the constitutionality, application, or operation of presidential decrees, proclamations, orders, instructions, ordinances, and other regulations, shall be decided with the concurrence of a majority of the members who actually took part in the deliberations on the issues in the case and voted thereon. Number 3. Cases or matters heard by division shall be decided or resolved with the concurrence of a majority of the members who actually took part in the deliberations on the issues in the case and voted thereon, and in no case without the concurrence of at least 3 of such members. When the required number is not obtained, the case shall be decided en banc, provided that no doctrine or principle of law laid down by the court in a decision rendered en banc or in division may be modified or reversed except by the court sitting en banc. Section 5. The Supreme Court shall have the following powers. 1. Exercise original jurisdiction over cases affecting ambassadors, other public ministers and consuls, and over petitions for certiorari, prohibition, mandamus, quo warranto, and habeas corpus. 2. Review, revise, reverse, modify, or affirm on appeal or certiorari as the law or the rules of court may provide, final judgments and orders of lower courts. In 3. All cases in which the constitutionality or validity of any treaty, international or executive agreement, law, presidential decree, proclamation, order, instruction, ordinance, or regulation is in question. 1. All cases involving the legality of any tax, imposed, assessment, or toll, or any penalty imposed in relation thereto. 2. All cases in which the jurisdiction of any lower court is in issue. 3. All criminal cases in which the penalty imposed is reclusion perpetua or higher. 4. All cases in which only an error or question of law is involved. Number 4. Assign temporarily judges of lower courts to other stations whose public interest may require. Such temporary assignment shall not exceed 6 months without the consent of the judge concerned. Number 5. Order a change of venue or place of trial to avoid a miscarriage of justice. 6. Promulgate rules concerning the protection and enforcement of constitutional rights, pleading, practice, and procedure in all courts, the admission to the practice of law, the integrated bar, and legal assistance to the underprivileged. Such rules shall provide a simplified and inexpensive procedure for the speedy disposition of cases. shall be uniform for all courts of the same grade and shall not diminish, increase, modify substantive rights. Rules of procedure of special courts and quasi-judicial bodies shall remain effective unless disapproved by the Supreme Court. 7. Appoint all officials and employees of the judiciary in accordance with the Civil Service Law. Section 6. The Supreme Court shall have administrative supervision over all courts and the personnel thereof. Section 7. Number 1. No person shall be appointed member of the Supreme Court or any lower collegiate court unless he is a natural-born citizen of the Philippines. A member of the Supreme Court must be at least 40 years of age and must have been for 15 years or more a judge of a lower court or engaged in the practice of law in the Philippines. Number 2. The Congress shall prescribe the qualifications of judges of lower courts, but no person may be appointed judge thereof unless he is a citizen of the Philippines and a member of the Philippine Bar. 3. A member of the judiciary must be a person of proven competence, integrity, probity, and independence. Section 8, Number 1. A judicial and bar council is hereby created under the supervision of the Supreme Court, composed of the Chief Justice as ex officio chairman, the Secretary of Justice, and a representative of the Congress as ex officio members, a representative of the integrated bar, a professor of law, a retired member of the Supreme Court, and a representative of the private sector. 2. The regular members of the council shall be appointed by the President for a term of 4 years, with the consent of the Commission on Appointments. Of the members first appointed, the representative of the integrated bar shall serve for 4 years, the professor of law for 3 years, the retired justice for 2 years, and the representative of the private sector for 1 year. 3. The clerk of the Supreme Court shall be the secretary ex officio of the council and shall keep a record of its proceedings. 4. The regular members of the council shall receive such emoluments as may be determined by the Supreme Court. The Supreme Court shall provide in its annual budget the appropriations for the council. 5. The council shall have the principal function of recommending appointees to the judiciary. It may exercise such other functions and duties as the Supreme Court may assign to it. Section 9. The members of the Supreme Court and the judges of lower courts shall be appointed by the President from a list of at least 3 nominees prepared by the Judicial and Bar Council for every vacancy. Such appointments need no confirmation. For the lower courts, the President shall issue the appointments within 90 days from the submission of the list. Section 10. The salary of the Chief Justice and the Associate Justices of the Supreme Court and of judges of lower courts shall be fixed by law. During their continuance in office, their salary shall not be decreased. Section 11. The members of the Supreme Court and judges of lower courts shall hold office during good behavior until they reach the age of 70 years or become incapacitated to discharge the duties of their office. The Supreme Court and Bank shall have the power to discipline judges of lower courts or order their dismissal by a vote of a majority of the members who actually took part in the deliberations on the issue in the case and voted thereon. Section 12. The members of the Supreme Court and of other courts established by law shall not be designated to any agency performing quasi-judicial or administrative functions. Section 13. The conclusions of the Supreme Court in any case submitted to it for decision in bank or in division shall be reached in consultation before the case is assigned to a member for the writing of the opinion of the court. A certification of this effect, signed by the Chief Justice, shall be issued and a copy thereof attached to the record of the case and served upon the parties. Any members who took no part or dissented or abstained from a decision or resolution must state the reason therefor. The same requirements shall be observed by all lower collegiate courts. Section 14. No decision shall be rendered by any court without expressing therein clearly and distinctly the facts and the law on which it is based. No petition for review or motion for reconsideration of a decision of the court shall be refused due course or denied without stating the legal basis. Therefore, Section 15, Number 1. All cases or matters filed after the effectivity of this Constitution must be decided or resolved within 24 months from date of submission for the Supreme Court, and unless reduced by the Supreme Court, 12 months for all lower collegiate courts and 3 months for all other lower courts. Number 2. A case or matter shall be deemed submitted for decision or resolution upon the filing of the last pleading, brief, or memorandum required by the rules of court or by the court itself. 3. Upon the expiration of the corresponding period, a certification to this effect signed by the Chief Justice or the presiding judge shall forthwith be issued and a copy thereof attached to the record of the case or matter and served upon the parties. The certification shall state why a decision or resolution has not been rendered or issued within said period. 4th, despite the expiration of the applicable mandatory period, the court, without prejudice to such responsibility as may have been incurred in consequence thereof, shall decide or resolve the case or matter submitted thereto for determination without further delay. Section 16. The Supreme Court shall within 30 days from the opening of each regular session of the Congress submit to the President and the Congress an annual report on the operations and activities of the judiciary. Article 9. Constitutional Commissions. A. Common Provisions. Section 1. The Constitutional Commissions, which shall be independent, are the Civil Service Commission, the Commission on Elections, and the Commission on Audit. Section 2. No member of a Constitutional Commission shall, during his tenure, hold any other office or employment. Neither shall he engage in the practice of any profession or in the active management or control of any business which in any way may be affected by the functions of his office, nor shall he be financially interested, directly or indirectly, in any contract with, or in any franchise or privilege granted by the government, any of its subdivisions, agencies, or instrumentalities, including government-owned or controlled corporations, or their subsidiaries. Section 3. The salary of the chairman and the commissioners shall be fixed by law and shall not be decreased during their tenure. Section 4. The Constitutional Commissions shall appoint their officials and employees in accordance with law. Section 5. The Commission shall enjoy fiscal autonomy. Their approved annual appropriations shall be automatically and regularly released. Section 6. Each commission and bank may promulgate its own rules concerning pleadings and practice before it or before any of its offices. Such rules, however, shall not diminish, increase, or modify substantive rights. Section 7. Each commission shall decide by a majority vote of all its members any case or matter brought before it within 60 days from the date of its submission for decision or resolution. A case or matter is deemed submitted for decision or resolution upon the filing of the last pleading, brief or memorandum required by the rules of the Commission or by the Commission itself. Unless otherwise provided by this Constitution or by law, any decision, order, or ruling of each Commission may be brought to the Supreme Court on certiorari by the aggrieved party within 30 days from the receipt of a copy thereof. Section 8. Each Commission shall perform such other functions as may be provided by law. Letter B. The Civil Service Commission. Section 1. Number 1. The civil service shall be administered by the Civil Service Commission composed of a chairman and 2 commissioners who shall be natural-born citizens of the Philippines, and at the time of their appointment, at least 35 years of age, with proven capacity for public administration, and must not have been candidates for any elective position in the elections immediately preceding their appointment. 2. The chairman and the commissioners shall be appointed by the President with the consent of the Commission on Appointments for a term of 7 years without reappointment. Of those first appointed, the chairman shall hold office for 7 years, a commissioner for 5 years, and another commissioner for 3 years without appointment. Appointment to any vacancy shall be only for the unexpired term of the predecessor. In no case shall any member be appointed or designated in a temporary or acting capacity. Section 2, Number 1. The civil service embraces all branches, subdivisions, instrumentalities, and agencies of the government, including government-owned or controlled corporations with original charters. 2. Appoints in the civil service shall be made only according to merit and fitness to be determined as far as practicable, and except for positions with their policy determining, primarily confidential or highly technical, by competitive examination. 3. No officer or employee of the civil service shall be removed or suspended except for cause provided by law. 4. No officer or employee in the civil service shall engage, directly or indirectly, in any electioneering or partisan political campaign. 5. The right to self-organization shall not be denied to government employees. 6. Temporary employees of the government shall be given such protection as may be provided by law. Section 3. The Civil Service Commission, as the central personnel agency of the government, shall establish a career service and adopt measures to promote morale, efficiency, integrity, responsiveness, progressiveness, and courtesy in the civil service. It shall strengthen the merit and reward system, integrate all human resources and development programs for all levels and ranks, and institutionalize a management climate conducive to public accountability. It shall submit to the President and the Congress an annual report on its personnel programs. Section 4. All public officers and employees shall take an oath or affirmation to uphold and defend this Constitution. Section 5. The Congress shall provide for the standardization of compensation of government officials and employees, including those in government-owned or controlled corporations with original charters, taking into account the nature of the responsibilities pertaining to and the qualifications required for their positions. Section 6. No candidate who has lost in any election shall, within 1 year after such election, be appointed to any office in the government or any government-owned or controlled corporations or in any of their subsidiaries. Section 7. No elective official shall be eligible for appointment or designation in any capacity to any public office or position during his tenure, unless otherwise allowed by law or by the primary functions of his position. No appointive official shall hold any other office or employment in the government or any subdivision, agency, or instrumentality thereof, including government-owned or controlled corporations or their subsidiaries. Section 8. No elective or appointive public officer or employee shall receive additional, double, or indirect compensation unless specifically authorized by law, nor accept without the consent of the Congress any present, emolument, office, or title of any kind from any foreign government. Pensions or gratuities shall not be considered as additional, double, or indirect compensation. Letter C. The Commission on Elections. Section 1. Number 1. There shall be a Commission on Elections, composed of chairman and 6 commissioners, who shall be natural-born citizens of the Philippines, and at the time of their appointment at least 35 years of age, holders of a college degree, and must not have been candidates for any elective position in the immediately preceding elections. However, a majority thereof, including the chairman, shall be members of the Philippine Bar, who have been engaged in the practice of law for at least 10 years. Number 2. The chairman and the commissioners shall be appointed by the President with the consent of the Commission on Appointment for a term of 7 years without reappointment. Of those first appointed, 3 members shall hold office for 7 years, 2 members for 5 years, and the last members for 3 years, without reappointment. Appointment to any vacancy shall be only for the unexpired term of the predecessor. In no case shall any member be appointed or designated in a temporary or acting capacity. Section 2. The Commission on Elections shall exercise the following powers and functions. 1. Enforce and administer all laws and regulations relative to the conduct of an election, plebiscite, initiative, referendum, and recall. Number 2. Exercise exclusive original jurisdiction over all contests relating to the elections, returns, and qualifications of all elective regional, provincial, and city officials, and appellate jurisdiction over all contests involving elective municipal officials decided by trial courts of general jurisdiction, or involving elective barangay officials decided by trial courts of limited jurisdiction. Decisions, final orders, or rulings of the Commission on Election contests involving elective municipal and barangay offices shall be final, executory, and not appealable. Number 3. Decide, except those involving the right to vote, all questions affecting elections, including determination of the number and location of polling places, appointment of election officials and inspectors, and registration of voters. Number 4. Deputize, with the concurrence of the President, law enforcement agencies and instrumentalities of the government, including the armed forces of the Philippines, for the exclusive purpose of ensuring free, orderly, honest, peaceful, and credible elections. 5. Register, after sufficient publication, political parties, organizations, or coalitions which, in addition to other requirements, must present their platform or program of government and accredit citizens' arms of the Commission on Elections. Religious denominations and sects shall not be registered. Those which seek to achieve their goals through violence or unlawful means, or refuse to uphold and adhere to this Constitution, or which are supported by any foreign government, shall likewise be refused registration. Final contributions from foreign governments and their agencies to political parties, organizations, coalitions, or candidates related to elections constitute interference in national affairs, and when accepted, shall be an additional ground for the cancellation of their registration with the Commission, in addition to other penalties that may be prescribed by law. 6. File, upon a verified complaint or in its own initiative, petitions in court for inclusion or exclusion of voters, investigate and, where appropriate, prosecute cases of violations of election laws, including acts or omissions constituting election fraud, offenses, and malpractices. 7. Recommend to the Congress effective measures to minimize election spending, including limitation of places where propaganda materials shall be posted, and to prevent and penalize all forms of election frauds, offenses, malpractices, and nuisance candidacies. 8. Recommend to the President the removal of any officer or employee it has deputized, or the imposition of any other disciplinary action for violation or disregard of, or disobedience to its directive, order, or decision. 9. Submit to the President and the Congress a comprehensive report on the conduct of each election, plebiscite, initiative, referendum, or recall. Section 3. The Commission on Elections may sit en banc or in two divisions, and shall promulgate its rules of procedure in order to expedite disposition of election cases, including pre-proclamation controversies. All such election cases shall be heard and decided in division, provided that motions for reconsideration of decisions shall be decided by the Commission en banc. Section 4. The Commission may, during the election period, supervise or regulate the enjoyment or utilization of all franchises or permits for the operation of transportation and other public utilities, media of communication or information, all grants, special privileges, or concessions granted by the government, or any subdivision, agency, or instrumentality thereof, including any government-owned or controlled corporation or its subsidiary. Such supervision or regulation shall aim to ensure equal opportunity, equal rates therefore, for public information, campaigns, and forms among candidates in connection with the objective of holding free, orderly, honest, peaceful, and credible elections. Section 5. No pardon, amnesty, parole, or suspension of sentence for violation of election laws, rules, and regulations shall be granted by the President without the favorable recommendation of the Commission. Section 6. A free and open party system shall be allowed to evolve according to the free choice of the people, subject to the provisions of this article. Section 7. No votes cast in favor of a political party, organization, or coalition shall be valid except for those registered under the partyless system as provided in this Constitution. Section 8. Political parties or organizations or coalitions registered under the partyless system shall not be represented in the voters' registration boards, boards of election inspectors, boards of canvassers, or other similar bodies. However, they shall be entitled to appoint poll watchers in accordance with law. Section 9. Unless otherwise fixed by the Commission in special cases, the election period shall commence 90 days before the day of election and shall end 30 days thereafter. Section 10. Bona fide candidates for any public office shall be free from any form of harassment and discrimination. Section 11. Funds certified by the Commission as necessary to defray the expenses for holding regular and special elections, plebiscites, initiatives, referenda, and recalls shall be provided in the regular or special appropriations, and once approved, shall be released automatically upon certification by the chairman of the commission. D. The Commission on Audit. Section 1, Number 1. There shall be a commission on audit composed of a chairman and 2 commissioners, who shall be natural-born citizens of the Philippines, and at the time of their appointment, at least 35 years of age, certified public accountants with not less than 10 years of auditing experience, or members of the Philippine Bar who have been engaged in the practice of law for at least 10 years, and must not have been candidates for any elective position in the elections immediately preceding their appointment. At no time shall all members of the commission belong to the same profession. Number 2. The chairman and the commissioners shall be appointed by the president with the consent of the Commission on Appointments for a term of 7 years without reappointment. Of those first appointed, the chairman shall hold office for 7 years, 1 commissioner for 5 years, and the other commissioner for 3 years without reappointment. Appointment to any vacancy shall be only for the unexpired portion of the term of the predecessor. In no case shall any member be appointed or designated in a temporary or acting capacity. Section 2, Number 1. The Commission on Audit shall have the power, authority, and duty to examine, audit, and settle all accounts pertaining to the revenue and receipts of, and expenditures or uses of funds and property owned or held in trust by or pertaining to the government or any of its subdivisions, agencies, or instrumentalities, including government-owned or controlled corporations with original charters, and on a post-audit basis, constitutional bodies, commissions, and offices that have been granted fiscal autonomy under this Constitution. B. Autonomous state colleges and universities. C. Other government-owned or controlled corporations and their subsidiaries. And D. Such non-governmental entities receiving subsidy or equity, directly or indirectly, from or through the government, which are required by law or the granting institution to submit to such audit as a condition of subsidy or equity. However, where the internal control system of the audited agency is inadequate, the Commission may adopt such measures, including temporary special pre-audits, as are necessary and appropriate to correct the deficiencies. It shall keep the general accounts of the government, and for such period as may be provided by law, preserve the vouchers and other supporting papers pertaining thereto. Number 2. The Commission shall have exclusive authority, subject to the limitations in this article, to define the scope of its audit and examination, establish the techniques and methods required therefor, and promulgate accounting and auditing rules and regulations, including those for the prevention and disallowance of irregular, unnecessary, excessive, or extravagant or unconscionable expenditures or uses of government funds and properties. Section 3. No law shall be passed exempting any entity of the government or its subsidiary in any guise whatever, or any investment of public funds from the jurisdiction of the Commission on Audit. Section 2. The Commission shall submit to the President and the Congress within the time fixed by law an annual report covering the financial condition and operation of the government, its subdivisions, agencies, and instrumentalities, including government-owned or controlled corporations, and non-governmental entities subject to its audit, and recommend measures necessary to improve their effectiveness and efficiency. It shall submit such other reports as may be required by law.